Start. Bismillah, alhamdulillah, salatu wassalamu ala rasulillah, ala alihi wa sahbihi wa man wala, thumma amma ba'd. To proceed. So, inshallah, we will try to cover the rest of what we started last time. We're at دلالة الأحوال تختلف بها دلالة الأقوال. The interpretation of statements changes based on the context in which they are made. The interpretation of statements changes based on the context in which they are made. دلالة الأحوال تختلف بها دلالة الأقوال. What does dalala mean? Indication. What is al-ahwal? Conditions, circumstances, conditions. تختلف, differs. بها, with it. Dalala, indication. Aqwal, statements. So when you want to translate this, you will say that the interpretation of statements changes based on the context in which they are made. So I started by mentioning وإن كان قميصه قد من دبر فكذبت وهو من الصادقين. So which translates to, and if his shirt is torn from the back, then she lied, and he is among the truthful. Why are we starting by this? Because this is one of the best evidences, the scholars that talk about qara'in and the utility of qara'in in the Islamic judiciary. What is qara'in? Qara'in is basically an evidence short of the bayyina. So if you have different types of evidences in Islam, we have bayyinat and we have qara'in. Bayyina is the evidence that is clearly legally admissible evidence in Islamic court. It meets the evidentiary standard in Islamic court. What is a type of bayyina in the Islamic court that we're all familiar with? The testimony of two trustworthy men. One woman, two women, one man, two women in certain cases. So this is like called the bayyina. Qarina is basically like an evidence that is not in the same strength as bayyina. Circumstantial. It is, the best translation would be what for qarina? You have to explain it. You have to explain it. It's an indication, something that indicates, the truth or otherwise of a particular assertion, but it is not a bayyina in the sense that it is not completely legally admissible. Now, do we ignore al-qara'in completely, or we use them to come to a point of ghalabat al-dhann, or the predominant assumption, ghalabat al-dhann, predominant assumption, or a point of probability that we would comfortable acting on? So we're not going to always act on certainties, but there will be a point of probability that would be comfortable acting on. This is called the ghalabat al-dhann, the predominant assumption. Will we use qara'in? In this case, this is a long discussion. It comes to admissible evidence in Islamic courts and the different evidentiary standards, but the position that I believe in is that qara'in should be used. Otherwise, we will do away with all forensic investigation, most forensic investigations completely, and will have no utility in the Islamic courts, and that will be detrimental to the cause of justice. But this is not a popular position, by the way. The admissibility of qara'in is not a popular position. It's the position of Imam ibn Taymiyyah, Imam ibn al-Qayyim, Imam ibn al-Ghars from al-Hanafiyya, Imam ibn al-Farhun from al-Malikiyya, but it's not a very popular position. although in all the madhahib they do use in practice the Quran to some extent, but at least theoretically speaking, there is a lot of, disputation in this regard. And you may say that the majority would disregard the Quran and they would only use al-bayinat that are traceable, to the Prophet and the companions. So tawqifi sort of approach to the issue of bayinat, what would be an admissible evidence in the Islamic court. Anyway, we're branching off. Come back. We're saying that sometimes you have qara'in, you have indications, you have indication, qarina is like dalala, but qarina shows that it is not, that strong of an indication. It is probable indication. But if you have 1, 2, 3, 4, 5, 6, 7 qara'in together, they can actually be stronger than sometimes a bayina. Okay, so we're saying that the indication of circumstances and conditions would have an impact on the indication of statements. And we have two statements. We have a statement from Yusuf alayhi salam, and we have a statement from the wife of Al-Aziz. She said he basically pursued me. He said she pursued me. And then two statements where we found a qarina. The Quran tells us that, this matter was adjudicated or settled by this qarina. His shirt was torn from the back. So apparently she was pursuing him and she pulled him from the back. If his shirt was torn from the front, then he was assaulting her and she tore his shirt from the front. So this particular ayah clearly shows the use of qara'in, because that particular indication or dalala, is it a bayina that is basically unestablished? No, it's not. It's just like, it's not like the two witnesses. It's just a qarina that gives you an indication, which the indication doesn't always have to be true, but also the bayina does not always have to be true, even if you have two trustworthy witnesses. The two trustworthy witnesses could be themselves confused, or they may be lying. They're trustworthy. How do we say that someone is trustworthy? We've not basically experienced lies from him before, and trustworthy, seems to be fine. But are these things guaranteed? Of course not. Could be extremely trustworthy externally, and in reality, not trustworthy at all. Okay, so the 151st maxim of Ibn Rajabiyya maxim, or al-Qawaaid Ibn Rajab, in the 151st maxim, Ibn Rajab rahimahullah says, دلالة الأحوال تختلف بها دلالة الأقوال في قبول دعوى ما يوافقها ورد ما يخالفها ويترتب عليها الأحكام بمجردها. The meaning of speech can be altered by the surrounding circumstances, which affect whether a claim is accepted or rejected, and rulings may be based solely on contextual indications. Contextual indications is basically history, my translation, I guess, for that statement. So the contextual indications here will be important, not only in the court, but we're talking primarily here about the court, but not only in the court, in the fatwa, in many other domains. Contextual indications will be important. So what are ahwal, what ahwal are we talking about? Seriousness, jest, joy, sadness, anger, contentment, etc. These are ahwal. These are conditions. What was your condition when you said that? you know, and that's basically it gives you, puts things in context, because you have content and context. When you zero in on the content and you ignore the context, you will be most of the time wrong. You can't zero in on the content and ignore the context. Context will always be important. In all matters, context is important. Context defines the content in all matters. Even when you talk about, you know, companies, you know, you talk about a company, the work that you do in a company, the context, the responsibility of leadership, the leadership of the company is to provide the context in which all the content takes place, all the projects. There has to be an overall context. They're, you know, the leaders are custodians of the vision, and they are responsible for providing the context in which everything happens. Context is always important. So I say here that the reason for including this particular maxim, دلالة الأحوال تختلف بها دلالة الأقوال, and another maxim, which is الأسباب والدواعي للعقود والتبرعات معتبرة. الأسباب والدواعي للعقود والتبرعات معتبرة. So الأسباب are causes, دواعي are motives for contracts, in contracts, and basically charitable donations or donations. معتبرة are to be considered. معتبرة are to be considered. So these two, we made them subsidiary under which qaida? Which qaida are we talking about now? Which major qaida are we talking about now? A days, now a weeks, now a months. الأمور بمقاصدها. These are judged by their intentions. So why are we using this and دلالة الأحوال? Because conditions and motives or causes are some of your best indications on the intent. So the condition and the motive or the cause of this statement, what triggered the statement, what prompted the statement is important. And the condition of the person making the statement is important. These are two important factors in discovering the intent. Why? Because the intent is very hard to discover. We're talking about intent. Do we have like a sort of an intent to scope, or we don't? And that is why we have to use whatever that's available for us to discover people's intents. Okay. So Ibn Rajab here mentions several applications of this maxim. One of the applications is divorce through implicit expressions. Divorce through implicit expressions. So we know that هناك صريح الطلاق وكنايات الطلاق. صريح الطلاق is explicit divorce. كنايات الطلاق is implicit divorce, right? So there are certain wordings for explicit divorce. You know, the madhab would disagree which words are explicit, but anyway. Within the framework of particular madhab, they have certain list of words. This is explicit divorce. These words would not be explicit divorce. Go back to your father's home is not an explicit divorce. That's, of course, it's not explicit. Now, go back to your father's home combined with an intention to divorce is what? Divorce. You are divorced. Is it contingent on intention? No, it's not. It's not, you know, clearly. So what if you say, one of the kinayat of the divorce, one of the implicit expressions of divorce in a state of disputation and anger. We will call this divorce. We'll call this divorce. If you say a word that is, implicit in a state of anger, we will call this divorce. Indirect expressions of slander, indirect expressions of slander. Is that like, slander that I'm talking about? I'm talking about qadf. I'm talking about accusation of adultery and fornication. So indirect statements, people are clever. They can make a statement that would not be explicit, just to not be charged. So people will be clever in making those accusations. So, but if you make them in a state of anger, argumentation, we count them as explicit. We count them as explicit. Or we count it, some said we count it as explicit, some said it is slander. It's implicit, but we will basically punish you for qadf, for accusations of fornication or adultery. This belief under duress. So someone was caught by the enemies and said words of disbelief. So is the fact that they are asra, they're captives, is that condition, their captivity, an indication that would basically clear them of disbelief? Yes, of course. The same applies to a prisoner giving confessions. Confessions, and we mentioned this, and this is amazing. This deen is amazing. The Sharia is amazing because we've talked about these details for hundreds of years. So a prisoner giving confessions or admissions in prison, particularly if torture is involved, will be thrown away and not considered at all by the court because the context here, shows that this is likely untrue. Mocking or quoting the testimony of faith also. So when someone says La ilaha illallah, to quote it or to mock it, and then he says, I did not embrace Islam, I'm not Muslim. Should we believe this? It depends on, we will not believe it if the condition does not allow us to believe it. Like if someone is sitting in the masjid with the imam after Salat al-Isha and and then says La ilaha illallah and everybody says takbir, and then he comes and says, I was just quoting the statement. No, please, this is not, Anyway, they had this discussion before for different reasons. Also, disputes between spouses over household items. So spouses are separating and everybody is claiming certain household items. How do we judge here? What is customarily for the man's would go to the man, and what's the customarily things that women use will go to her, and things that are for men will go to the man. Disputes between artisans over tools. Every artisan gets the tools that belong to their profession. And then implausible claims. Implausible claims, and this is, عدم سماع الدعوة. This is a legal term called عدم سماع الدعوة. And this term has its roots in our fiqh, particularly in the Hanafi and Hanbali madhabs. As far as I am aware, I haven't really, I'm not really sure about the Maliki and Shafi'i madhabs here, but in the Hanafi and the Hanbali madhabs, there is this concept of عدم سماع الدعوة. You don't even listen to the charges because they are so ridiculous. Like you're not going to be basically entertain the allegations because they are ridiculous. So someone says, that the Khalifa came and got a bundle of vegetables from me and didn't pay, well, probably the Khalifa will not, you know, venture out of their palace to buy vegetables from you, and likely they don't have a reason to deny payment and stuff like that. So if someone makes a claim of that nature, we will basically not give them the time. Otherwise, if the court can be overwhelmed by the amount of ridiculous allegations people make. So condition here, you know, so this is the Khalifa. You know, what you're saying, you're making an allegation here. We're not going to really spend time entertaining this because it doesn't make sense within the larger context of things. So based on this maxim, Imam Abu al-Abbas argued, so Abu al-Abbas is another way to say Taqiyuddin, another way to say Ibn Taymiyyah, the grandson, because that's his kunya. So Imam Abu al-Abbas argued that marriage can be valid even without specific wording. So listen to this, what Imam Taqiyuddin said. He said, it's well known that the contextual indications of marriage are recognized, such as people gathering for that purpose and discussing it openly. If after such a gathering, someone says, like we're having a big gathering, you know, family members from both sides are here to celebrate. We have the cake, we have all the stuff, you know, we have dinner for everybody, etc. And then after all of this, if someone says, I have given her to you for 1,000 dirhams, they used to say that, you know, I have given her to you. They do not necessarily in marriage for 1,000 dirhams. Probably people will not be saying this way nowadays, but that is an expression they used. The father would say, the 1,000 dirhams is the mahr, which is the wedding gift. So they would have to designate, they will designate the mahr in the statement, you know, they don't have to say it, but they will just say, I have given her to you for 1,000 dirhams without saying in marriage. Is that enough? So Imam Taqiyuddin said, given all the above, yes, it is enough. You know, you have people here celebrating. It cannot be understood otherwise within that context. Within that context. This is not the dominant position in the madhab. So please try to be sort of careful when you do this so that your marriage is basically valid according to the agreement. There is no reason for us. He was not saying this for you to go out and do this. He was saying this for post-mortem. Someone had done this, they are married, should we basically question this marriage? So, but if you're going to get married, just do it right and do the proper ijab and qabul. In the madhab, the ijab has to come before the qabul. So I have given my daughter so-and-so to you in marriage. You don't have to say for how much, or the mahr, you could have agreed on the mahr already, but I have given to you. Or in you know, in the Hanafi madhab, she can say, you know, I have given myself to you in marriage, and that would be valid in the Hanafi madhab. There is a riwayah in the Hanbali madhab, by the way, that if she does this with the permission of the wali, it is valid. But that is not the dominant one. Can a woman marry herself off? So in the Hanbali madhab, no. In the Hanafi madhab, yes. But in the Hanbali madhab, they entertain the possibility of the wali being okay with it, the wali giving permission, and then she goes and marries herself off with the permission of the wali. Is that valid? In one report in the Hanbali madhab, it is valid. In the dominant report, no, it is not valid. She still needs the wali to give her in marriage or to marry her off to the suitor or to the future husband. So, but in the Hanafi madhab, it is okay. So, in order for you to do it right, why don't you do it why don't you make it valid according to the agreement by having your wali saying to the suitor, I have given to you in marriage, and then the suitor will say, I accept, and that is the ijab and qabul. If this happens in front of two trustworthy male witnesses who have not been asked to keep it secret, this is a valid marriage according to all. So try to do it right if you like, and so that it's valid according to all. Now, so hopefully this maxim is now clear. Conditions, circumstances, your state of anger, contentment, disputation, argumentation, grief, sorrow, joy, your condition will affect our interpretation of your statements. If you say to your wife, kinayat al-talaq, or an implicit word of talaq in a state of anger, this is going to be different from saying it while you're having breakfast together, happily. So we will have to figure out how to interpret the statement within that context versus that context. Okay. Now, the next قاعدة is الكتاب كالخطاب والإشارات المعهودة للأخرس كالبيان باللسان. These are two قواعد. الكتاب كالخطاب is one قاعدة. Written communication is treated like verbal communication. And the established gestures of a mute person are considered equivalent to verbal expression. الكتاب كالخطاب. الإشارة المعهودة من الأخرس كالبيان باللسان, right? كالبيان باللسان. الكتاب is, how do you translate الكتاب? Written communication. So like الكتاب is a book, but here it means written communication. كالخطاب, like الخطاب, verbal expression, verbal communication. So written communication is like verbal communication or like speech. الكتاب كالخطاب. Okay. These expressions are the expressions of مجلة الأحكام العدلية. مجلة الأحكام العدلية. Remember last time we were talking about this is the Shafi'i expression, but it is an agreement with our madhab. This is the Hanafi expression. مجلة الأحكام العدلية is based on the Hanafi madhab, but this is in agreement with other madhab, so that's fine. To borrow expressions from one another is completely fine if the expression is an agreement. Okay. So these two rulings, so الكتاب كالخطاب, and this الإشارة المعهودة من الأخرس, I translated this as established gestures, established versus non-established. So it has to be معهودة, it has to be established, customary. People recognize this as an indication of that. People customarily who understand the isharat or the gestures of the mute person will understand, people who understand American Sign Language. Someone is speaking American Sign Language, ma'huda or not ma'huda, established or not established. And in this case, it would count like bayan bil-lisan, like verbal expression. Kal bayan bil-lisan, like verbal expressions. Okay. Some of the scholars will put these under which qaida? Al-'ada muhakkama. Custom is authoritative. Custom is authoritative. Al-'ada muhakkama. Do they belong to that qaida? Can they be subsidiary maxims of al-'ada muhakkama? Yes, of course. However, many subsidiary maxims can fall under different qawa'id, different sort of qawa'id kulliyya, So in this case, do they belong there more or they belong here more? I had to choose to put them here under this one in the book or to put them under the other one. I felt they belong here more because they are referring to what? The importance of intent. It's all about intent. Whether you express your intent in writing or you express your intent in speech, what matters is your intent. Whether you express your intent in gestures, writing, speech, all the same. Long as we're able to clearly judge or discover the intent, as long as we're able to clearly do it. So we will have guidelines, and in certain scenarios, we'll have istithna'at, exceptions, because these qawa'id are aghlabiyya or kulliyya. Aghlabiyya, which kulliyya means universal, aghlabiyya means predominant. No, they are kulliyya, they are universal. I'm sorry, I framed it in a way that would make you say what you said. They are kulliyya, they are universal, but they will always have exceptions. Why? Because of the overlap of qawa'id, because here's the problem. Most of the disagreements that happen between us is because of the complexity of judgment. When you judge anything, there are multiple concerns, multiple considerations. Some people ignore some of the concerns and considerations. Some people are unable to see some of the concerns and considerations. Some people ignore them. Some people prioritize some over the other, and that prioritization could be sometimes misguided when they prioritize a certain value over another value. That's generally why we disagree, not because some of us are ethical and some of us are unethical. Sometimes that can be true, but most of the time because we are disagreeing over basically sometimes it's and your scope varies. Basically, your visual field is dependent on your knowledge, and your consideration of different concerns in judging a particular issue. Will vary depending on will vary depending on your ability to see all the concerns and your prioritization within that framework or within the particular context. Which value are you valuing more? Do you value justice over, caution? Or do you value caution over justice? Whatever it is that you will value in different contexts. So, okay. We branched off. Where were we? Okay, let's go back. Some of the scholars, I talked about this. Okay, so these قواعد will also fall under العقود تصح ما دل على مقصودها من قول أو فعل. العقود تصح بكل ما دل على مقصودها من قول أو فعل. This قاعدة actually brings in all of the above. So الكتاب كالخطاب. Written communication is like verbal communication. الإشارة المعهودة من الأخرس كالبيان باللسان. Clear gestures, established gestures of a mute person are like a verbal expression. What are they saying? They're saying that we have three different ways. Verbal expression. We have written expression. have gestures. Can people use any other way to express themselves or express their intent? No. No other way. Huh? Other than these. No, there is none. That's it. People cannot express their intent by anything other than this. What? AI? What's iPhone for? Huh? The cell phone? How are you using it to express yourself? You're using AI to do what? Okay. Oh, but gestures don't have to be sign language, keep in mind. When you place a signpost or, in the land to indicate the borders of your territory or property, is that communicating something? Yes, communicating. What does it fall under? Gestures. So it will have to fall under one of these three. So when Imam Taqiyuddin says, العقود تصح بكل ما دل على مقصودها من قول أو فعل, contracts are valid by whatever indicates their purpose, whether by word or action. Does that bring under it verbal, written, gesture? Anything that indicates the intent, the contract will valid by anything that indicates the intent. However, in order for us to use this, whatever indicates the intent has to be established, like has to be clear and established, right? Okay. So, al-qalam ahad al-lisanayn. This is a usual expression in Arabic. Al-qalamu ahad al-lisanayn, which means what? The pen is one of the two tongues. That's the literal translation. The pen is one of the two tongues. Huh? No. It's just a statement. Al-qalamu ahad al-lisanayn. The pen is one of the two tongues. So the Messenger of Allah was commanded an yuballigh ma unzila ilayhi min rabbihi, to deliver that which has been revealed to him from his Lord. How did he deliver it? By speech and writing. Did he not write to the kings? And he wrote. He also wrote to his agents and officials and governors and zakat collectors and all of that stuff. So he communicated. Keep in mind that he also communicated in gesture. When he said, "Ash-shahru hakadha wa hakadha wa hakadha," the month is like this, or like this, indicating 29 or 30 days by the hand gestures. That is communication. Is this considered balagh from him? Valid balagh from him? Of course, valid balagh from him. So valid balagh from him happened by verbal expression, by written expression, and by gestures as well. Okay. And Ibn al-Najjar here says, the basis of written communications in the Quran Sunnah is the Quran, the Sunnah, and Ijma'. So he mentions from the Quran, إِنِّي أُلْقِيَ إِلَيَّ كِتَابٌ كَرِيمٌ إِنَّهُ مِنْ سُلَيْمَانَ. So I have been delivered a noble letter. And he says the Prophet also corresponded with kings and governors and so on. And the Ummah has agreed on accepting letters from one judge to another because necessity dictates it. Necessity dictates it. Did this happen during the time of the Prophet ﷺ? No, but necessity dictates it. This is important. So we will always be negotiating with circumstances, the conditions. We will not be, in isolation from the context. When the Islamic, when the Muslim state becomes much larger, and then we will have to take things in consideration. When Umar radiallahu anhu said, the people responsible for the blood money will not be the asaba anymore. They will be people registered, people in the same registry. He had a reason to say this, and the reason was the prompt establishment of justice and compensation for the victims of the family. If people are moving around, I'm not going to go back to Yemen to bring the compensation, to bring the daya from the family of this person, like Shu'ba min al-Azd, Shu'ba ibn al-Hajjaj, Azdi. We'll come to talk about Shu'ba later when we talk about hadith. So he's living in Basra. I'm not going to go back to Yemen to collect his daya. The people in Basra will have to figure it out among themselves. People in the same registry will have to figure it out. So necessity dictates it. By the way, the Shafi'is and Hanbalis did not take that position from Umar, like Hanafis and Malikis did. Just to tell you that this is still controversial. We still can have disagreement over things without accusing each other of different accusations. So then he says, the Ummah has agreed, and it's because the necessity dictates it, and then he justifies it with sort of a reason. He says that if, something can happen in a certain place and you will need to basically press charges another place, these two judges, if the one judge has the witnesses are here, the charges need to be pressed here, the witnesses cannot travel, you can't ask the witnesses to travel, it would be impracticable or not feasible to ask the witnesses to travel. So this judge will take the testimony of the witnesses and write to that judge, and so on and so forth. So they have to communicate through writing. So that is the concept of Kitab al-Qadi, or the letters of judges. Some people have written, master's degrees and maybe PhDs on the communication between the judges. Al-Buhuti, rahimahullah, says, if a man writes an explicit statement of divorce in a clear manner, it takes effect even if he doesn't intend it. Even if he doesn't intend it, because writing is explicit in divorce. And then he eventually will say, as writing serves as a substitute for the verbal declaration. Writing serves as a substitute for the verbal declaration. So writing is explicit in divorce. Is that really, the Hanbali position? That when you write you're divorced, this is explicit, not kinaya? It's a matter of disagreement. It seems that the Mutaakhirin had chosen that position, but it was a very strong disagreement before them, and many of the Mutawassitin chose that writing is not explicit. Writing is one of the kinayat of al-talaq, meaning what? Implicit expressions of divorce. What is the difference? If you write without intending divorce, it doesn't count. If it is implicit, if we consider it implicit, we will wait for your intention to determine if this is valid or not valid divorce. If we consider writing explicit, we will not wait for your intention. It will be a valid divorce regardless of your intention. However, even the Mutaakhirin will come back and say alternative explanations or interpretations will be accepted. Alternative explanations will be accepted. So if you write and you say, لم أرد بذلك إلا تجويد خطي أو غم امرأتي, I did not intend by this except to improve my handwriting or to cause distress to my wife, then I will believe you that this is what you intended. You did not intend divorce. Okay. So eventually in the Hanbali madhab, the bottom line in the Hanbali madhab, if someone writes divorce and then claims that this was not intended, but what is intended is such or such and such, we will accept that. If a male person, now, next is, I'm quoting الإقناع here, كتاب الإقرار وهو إظهار مكلف مختار ما عليه لفظا أو كتابة أو إشارة أخرس. الإقرار, what is الإقرار? إقرار is acknowledgement. When you acknowledge a right that is upon you, when you acknowledge an obligation, a liability, you acknowledge it, whether in speech, writing, or the gesture of the mute person, then this will be all valid. If a mute person's gestures were not recognized, they could not transact, and that's a hypothetical here. If we did not recognize their gestures, if we don't recognize their gestures as valid, that will be a death sentence to the mute person. Because, it's a death sentence. Because you're telling him you are unable to communicate with the world. So that would be cruel. That is why it's a necessity to recognize the gestures of a mute person. And once they are interpreted, they're valid, but they have to be ma'huda. They have to be established. They have to be customary. Because also we do not want we're pursuing the here, and so his gestures or her gestures have to be customary, have to be established. Now, if they are not clear and we're having doubt about them, we require 2 translators. Trustworthy translators will be required. If they are ma'huda and someone can understand them, that's fine. If they are not clear, then we will require 2 trustworthy translators who can translate his gestures or her gestures or sign language. Al-Buhuti then states, divorce is enacted through a clear gesture by a mute person only, as it stands in for their speech, or it is substitute for their speech. If this gesture is only understood by some people, it's considered the kinaya. So what is kinayat al-talaq and sarih al-talaq for a mute person? Or the kinayat al-talaq would be a gesture that is not clear-cut. Sarih al-talaq will be a gesture that is clear-cut. So kinayat al-talaq will have room to be reinterpreted. Sarih al-talaq not. And then in al-iqna' it says, if the mute's gestures or writing are understood, their li'an, okay, so li'an and qadhf. Li'an is mutual cursing, public what? Imprecation, mutual cursing. It's when the husband claims that the wife has committed, adultery. And then they come and then they do this mutual cursing. In the Jewish tradition, it's, just compare between the Jewish tradition and the Muslim tradition. In the Muslim tradition, eventually, who will be the final, speaker here? She will be the final speaker. We are coming from a position of presumption of innocence, and we will maintain the position of presumption of innocence. But because of the different relationship between the wife and husband, we will not treat him like any foreign man. It would be unfair to treat him like any foreign man. So we will give him basically the benefit of the doubt also, and simply ask him to do the li'an. And if she participates in the li'an, we will finally defer to her. But we will not basically charge him with qadf. We will not convict him of qadf. That is the difference between a foreign man and the husband. So if a mute person makes li'an, can a mute person make li'an? Yeah, yes, if it is understood. Can a mute person make qadf? Yes, if it is understood. If he wants to take it back, take it back. You know, he regains speech and he says, you know, whatever it is that I indicated, whatever it is that you understood from my previous gestures, I didn't intend it, you know, I take it back. So will we go by this? Will we accept this? We will accept it in li'an, not in qazf. Not in qazf. Qazf, when you accusation of innocent people of fornication or adultery, we will not accept this. But li'an, we will accept it if the change of position is against him. So he says, I didn't mean it because, you know, maqasid al-Sharia is what? We want her to be innocent. Like, does the Sharia want her to be innocent or guilty? The Sharia wants her to be innocent. So if he goes back and he says, you know, if he takes it back after he regains speech, we will apply the had and we will establish the nasab. Apply the had on him and establish the nasab or his paternity. Okay. Then scholars differed on accepting the gesture of someone whose tongue is restrained. معتقل لسانه. So if his tongue is restrained, we will wait 3 days. In the bottom line, we will give him about 3 days of wait. But there are a lot of disagreements over the one whose tongue is restrained. The prevailing view is that it's not accepted for his acknowledgement and transactions if there is hope in regaining speech. However, even if there is hope in regaining speech, it will apply in acts of worship. Like he could say Bismillah, you know, if he's making wudu, he can basically say Bismillah, you know, because he's unable, his tongue is restrained. He can gesture the basmala. But we will not allow it if there is hope of regaining speech because he's not a mute person. And usually people, you know, who are, you know, there are many medical conditions where you can't speak, you know. So if you're just unable to speak and people are waiting to see if you're going to be, you know, if this is going to go away or not, then there is no hurry here to basically sell your apartment building. You know, just keep him, well, let's wait and figure this out. So you can sell your apartment building through gestures. In other words, if there is hope that you can regain your speech. In li'an, for instance, if the hope is lost of regaining speech, it will be accepted, the gesture will be accepted, and we will give him 3 days, basically. We will give him 3 days, and if the return of, if regaining the faculty of speech is anticipated, we will wait 3 days. And if we lost hope completely, then we will go ahead and accept his gestures. Exceptions from these Qawaaid. The first one is non-acceptance of a judge's letter in hudud. Non-acceptance of a judge's letter in hudud. When does the judge letter not work? When does the judge's letter not work? There's a lot of disagreement over this, even within the madhab. What about equal retribution, qisas? Qisas. Is a judge's letter in qisas accepted? Yes. Because all of the rights of al-ibad, the judge's letter is accepted in regard to disputes over rights of al-ibad, rights among people, among themselves. But punishment can be, we punish people because they violated the rights of the creator and they violated the rights of the creation, right? If they violated the rights of the creation, we will accept the judge's letter all the time, even in some hudud, in which had do we prioritize the right? The DAs, when they press charges against a defendant, do they talk about the community, whatever, New Jersey, whatever the people of New Jersey is, who's pressing the charges? The people of New Jersey, right? This is al-haqq al-am, this is the right of the public. This is different from the al-haqq al-khas, which is the right of an individual entity. Okay, so al-haqq al-am for us is the haqq of Allah, and al-haqq al-khas is the haqq of al-ibad. There is one had in which we prioritize haqq al-ibad, which is qazf. Qazf is the one had in which we prioritize haqq al-abd. In this case, the judge's letter will be accepted in all things, including qisas, according to the prevalent position in the madhab, and including hadd al-qazf, but will not be accepted with regard to the other hudud. Why? Because haqqullah mabna ala al-musamaha. Because the right of Allah is based on musamaha, leniency. Allah likes to pardon. Allah likes to forgive. Therefore, I don't have to establish the hadd against you. I don't have basically to take the extra step and have one judge write to another judge, and there is a possibility that the book was tampered with, the letter was tampered with. There are possibilities here. It's not, and al-hudud tudra bil-shubuhat. Al-hudud must be repelled as much as possible by doubt, uncertainty. So when a judge writes to another judge in a faraway city, there is an element of doubt that is creeping into this. So why? Al-hudud tudra and haqqullah mabna ala al-musamaha. The rights of Allah subhanahu wa ta'ala are based on leniency. Strictness applies to the rights of al-ibad. The second exception is the writing of divorce. Although explicit by some, others consider it kinaya. Even if it is explicit, alternative interpretations will be accepted. Alternative interpretations will be accepted. So why is it an exception from the qaida? Because the qaida wants to equate kitab bil-khitab, written and verbal expressions. We're saying, no, they are not always equal. So it's an exception. We will, so some will say that kitabat al-talaq is kinaya, and even those who say it's not kinaya, it is sarih, they still leave room for accepting alternative interpretations. Testimony of a mute person not accepted, even if the gesture is understood, unless it is given in writing. Testimony of a mute person. When a mute person comes to testify before the court, we are establishing guilt against someone else by the gestures of the mute person. How comfortable are we? How comfortable are we taking the gestures of a mute person as, solid evidence against that person to establish guilt? We will be less comfortable. We will be less comfortable and taking a verbal expression. Therefore, there is disagreement within the madhab. Should the mute person be able to testify before the court? There is disagreement. The predominant position is no, unless he gives it in writing. There is another strong position which says yes, if it is clear. if it is clear, if people really can find, if the mute person can clearly express, particularly when it comes to something they have seen, that they have observed. And the same applies to a deaf person. Can a deaf person testify? Yes. Testify about what? What they have observed by their eyesight. They can testify about what they have observed by their eyesight. And are these discussions warranted? Yes, because a deaf person seeing a crime scene is not hearing what is being said. So does this impair their ability to understand the context? It does impair their ability. But if they will have to testify and they are just simply reporting what they have seen, we will accept it. Finally, a mute person's gesture, understood or not, is an action, is like an action. This is an exception. We're saying الكتاب كالبيان باللسان. إشارة الأخرس المعهودة أو الإشارة المعهودة من الأخرس كالبيان باللسان. So the mute person's gestures are like speech, are like verbal expression. Okay, so a mute person is praying, and then he does this. And then the person in front of him understood what he's saying. Did he speak in the prayer? If he speaks in the prayer, it's valid or invalid? Invalid. Okay. If he basically moves in the prayer, which move in the madhab, كثيرا قليل. If there is much movement, it will invalidate the prayer. If it is not much, if it is not considered much to disrupt the prayer, it's an action that does not invalidate the prayer. Now, when a mute person does this, I don't know, I'm supposing this would mean something eventually. Did he speak? Is his prayer invalid? So just keep this in mind. In the madhab, no, he did not speak. In the madhab, he did not speak. What if he does this during khutbah al-Jum'ah? Would that count as speaking? Yes. During khutbah al-Jum'ah, this will count as speaking. During the prayer, it will count as an action. During khutbah al-Jum'ah, it will count as speaking, because eventually he will be liable for speaking during khutbah al-Jum'ah, but it will not ruin his Jum'ah. It will, he can still pray Jum'ah, and but if we consider it to be speech during the prayer, it will invalidate his prayer. So that's a distinction they make. So eventually, what you want to understand is the importance of intent, and everything is based on intent. And how you express this intent in Islam is secondary. It can be expressed through verbal expression, which is the clearest, most precise, but it can also be expressed in writing or gestures, different gestures. But what matters is the intent. Now, what matters is the intent, but we have to have some regulations and guidelines to be able to discover that intent, because it's not always straightforward. Written expression is not always straightforward. Gestures are not always straightforward. All of this discussion is to ascertain the intent. And it shows you our respect for the truth also, our respect for the truth. There is, objective truth out there that we should be all pursuing. And that will bring us to the end of this session. And inshallah, next time, we will be talking about different applications of al-umur bimaqasidiha. These are judged by their intentions in the areas of ibadat and معاملات. قولوا قولي هذا واستغفر الله لي ولكم. سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك.